Very good. And what is it? Thank you.
Yeah, please, Your Lordship. I better answer item number 13, my lord.
Item number
Item number 13, 1-3, my lord. Yesterday has not been received, my lord. And moreover, my lord, service has not been completed. She may give a reminder, my lord. I have checked the office now.
it is a POCSO.
Yes, ma'am.
Your office has already received the notice.
It's already given, but the instruction whether it's service completed or not, we have taken the
And that upon what you have submitted, the C considering the request, the submission made by learned counsel for the petitioner, Mr. Ihoff, matter be adjourned. And the report we call for. Please the matter before vacation you want.
before vacation slot. You want 22 Lordship?
Pardon?
22.
What he said, this standing council, whether it will be received by Monday or
Yes, Lordship. You already informed me that you will be received shortly. So any date may be fixed before
22nd.
highly advised.
May I please, Your Lordship? I beg to mention item number 7, Lordship. Elshare is not available.
Here we need the scan copy of the TCR. TCR not received. Raised is hereby directed to call for the same by issuing reminder. Raised matter. It is a charge sheeted case, na?
Yes, Lordship.
So I don't know the last week whether those all
Your Lordship, earlier on 2 occasions, the trial court records was called for. It has not been received yet, Your Lordship.
But your petitioner is in custody since when?
Yes,
Long such period. What we can
Your Lordship, since 16th of March 2024.
16th of March
Yes, Your
2024.
Yes, Your Lordship.
Oh, more than a year.
Yes.
Ahibo Zanu, Pari. Maybe Kamru Metro? From Kamru Metro or where?
Yes.
Yes, Your Lordship, it's Kamru Metro.
Did you? 20? 23rd of September.
Obliged.
I beg to mention item 27, Lucy. In this case, I have taken consent. I'm from the petitioner. And I have taken consent from the respondent. So,
27.
yes, Lucy.
Ah.
Lordship may adjourn this matter and fix the matter after a vacation.
You are for the petitioner.
After
Will consent
taken-
to the other side. And it comes to the petitioner. You are Mr.
H80, Lucy.
H8 paid for an adjournment. Where allowed, please the matter. It will be after vacation. only.
Yes.
At least after vacation as an it.
Obliged.
Lordship, in item number 2, it is in admission column, Lordship.
Item number?
Admission column. Lordship, we have
Item number?
2. In admission.
Yes, 2. Yes.
Lordship, we have the CD, but Lordship matter may be fixed on any other date, Lordship. We make for pardon, Lordship, adjournment.
You are for the
Lordship, I am for the petitioners. Lordship, this is a criminal petition, even though it's a quashing application, my lord. It's a minuscule issue of clubbing this matter with already pending 4 or 5 other cases, my lord. So there's some urgency on our part. I honor his request, my lord. So Lordship, next week, any date may be given. It's a very small issue that requires to be addressed, my lord. But some as per his convenience, but before the
22nd,
vacation, my lord.
On
22nd.
22nd. CD need to be written.
Otherwise, what we call for actually, CD was called
It
for.
was called for. It is received, Lord.
That may be retained, my lord.
It can be written, I think.
Not
Come for the respondent number
Heard
2.
Mr. Heard Mr. D.K. Paita, the learned counsel for the petition. Also heard Mr. K.K. Das, the learned additional PP appearing on the and you are S. Rahman.
Esther.
S. Rahman appearing for the respondent. Respondent number 2 of the is submitted by Mr. Das, the learned additional PP. Some time is required. It is required for the written an adjournment. prayer around listing matter according 22nd of September. CD be retained till next.
That is all, my lord. Deeply obliged, my lord.
May I please your lordship? Lordship, in item number 19, lordship. But the last order, the IO so the PP additional PP sought time for a information, lordship, a report. But that report is not in record, lordship, today also.
We have not received lordship.
What kind of report that was?
Lordship, that is a producing lordship, they have alleged that it is a fake authenticity of a
Oh,
birth
yes, yes.
certificate.
Yesterday I have gone to this,
Not-
this one birth certificate.
Not-
is
not-
done.
not-
The report you have not received.
Not received, no.
Otherwise, you are on interim or you
Lordship,
are
I'm in interim. But the CD is already there. Can it be before vacation, lordship? Since June, it is pending, lordship. I'm on interim. Because the CD is already there only for the
Does
report.
can we accept the report within the short period? Otherwise, it will be listed after vacation and CD may be returned back. Or otherwise, if you say that report may receive, then it will be listed
We will do the best lordship before vacation.
before vacation.
After vacation, no. In time.
Try going for a vacation. Let it be before vacation. The CD is already there only for the report, lordship. Last date also the CD was there, but the additional PP sought time for the report. Hence,
On 26. On 26, lordship.
No.
Lordship. Any date, lordship, maybe.
No, late.
And a date. A date.
This is demand by command, I think.
before vacation.
Maybe 24, 25th we are here.
25th, then, lord.
25th.
No.
Report not received. Issue remind learned additional PP will take necessary steps. Listing matter according to 25/9/2025. CD be retained till next date of listing. And
interim may
interim be continued.
Deeply obliged.
Thank you.
May it pleases your lordship. Lordship on 8-9, item number 37, lordship passed an order because there was a attachment thing going on, lordship. Lordship, the order is shown here. He find that the order is uploaded, but when we apply, lordship, it is not uploaded. So we are, maybe there is some glitch, lordship. So I pray that again it
Item
can be
number,
uploaded.
just tell us, item number,
Item number 37. Dada found it
on which date it was?
on 8-9, lordship. Order is also there. Only thing, or কিন্তু আমি upload to পোৱা নাই আমি হেৰি
There
কৰিলে
may be some,
order is some
some
glitch
systematic issue may be there, so we'll just definitely will.
highly applies because we need it today itself, lordship. So because
Okay.
otherwise the
We'll try.
attachment,
I'll
lordship.
send it to email. So we'll
Or
definitely,
else can I take a copy, lordship, from the court?
that I cannot say. You have to apply
Okay,
for such-
I'm applying. If it is not uploaded, lordship, then they won't be able to give us also. So
We'll
that-
see to it definitely in first half only we'll try.
highly applies, lordship.
Thank you. Then, cosa lihat Bapak. Itu ada isu as. Apa yang bahasa? Namanya apa? Cosa di boleh.
For delivery of order, item number 30.
This revision is allowed. And the order dated 15/3/2023, passed in so and so, Karimganj is hereby set aside and prayer for amendment is allowed. Accordingly, defendant number 1 is hereby directed to file this amended written statement. However, the amended written statement may be accepted only if it is jointly filed by all the defendants.
LCR may be returned back, lordship, because
LCR was there, na?
lordship.
Okay, 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 we are returning back. It will get in mind. Okay, we'll return back then. That's
Obliged.
That's what fair. That's what fair. Return back. Just a second, Mr. Hussain. It is yes. No, LCR to accent हुए थे. LCR said.
I think LCR
Scan
is
copy.
not there, perhaps.
Is it a scan copy or LCR? Entire
Not
LCR is
LCR,
there.
I think it is a service copy. perhaps.
These are service copy perhaps. Copies of service
Service
copies.
copy, I think.
LC other respondents. LC was called.
I think
All
not,
for LCR, I
not,
think.
Not, my lord, perhaps.
perhaps not, Lord.
Hmm.
Because so many respondents are there.
So
Lord.
many respondents are there, that's
Lord.
why most probably it is all the service copy.
Lord.
Yes.
Hmm. With them. So, okay. Here, we have received the scan copy, I think.
Yes, lordship. May I please your lordship.
Who is taking up this? Okay, okay. Yes, ma'am.
Here the petitioner was arrested on 12/12/2023. As on date, lordship, 1 year, 9 months. Recovery is lordship 297 gram of heroin from two other person. I'm not named even in the FIR.
Recovery was not from your direct conscious position.
Yes, lordship. I'm coming to that, lordship. Even lordship, I'm nowhere named. 297 grams from two other people. Those two people were arrested. Charge sheet was submitted, lordship, against 5 persons. And charges were framed. Charge sheet was submitted on 31/7/2022. Petitioner was arrested on the strength of NBWA. Charge sheet was submitted on 31/7/2022. Total cited witness is 9, my lord. Charges were framed on 28/9/2022. Now, lordship may kindly come to the
Just a
FIR.
second, 28
Charges.
charges were framed.
28/9/2022.
So you were shown as an absconder or subsequently charged?
No, lordship. I was shown as absconder on the very first day when the charge sheet was submitted. But lordship, in the case, in as much as against 5 persons, charge sheet was submitted. The learned court below was of the view that in this charge sheet only 2 persons are named. Therefore, charges were framed against 2 persons. Subsequently, lordship, after perusal of the entire case record,
Oh, acha.
yes, I'm coming to that, my lord. Lordship may kindly come to page number 24, the FIR 22. Page number 22. Lordship. This is to inform you that a reliable information was received from a source by me at so and so. As per the information, a large quantity of suspected narcotic drugs had been kept concealed inside a Alto vehicle bearing registration number so and so, and the vehicle will move from South QT to so and so via so and so in between so and so. The informer also revealed that there are 2 drugs peddlers present inside of the Alto vehicle. Lordship may kindly come to the next page, 23. Second paragraph. We reached the spot at 9:45 a.m. and started Nakaseking at so and so bypass, and at around so and so I noticed the vehicle bearing number so and so at bypass so and stopped it. Search of the vehicle was conducted by me with the help of police party in presence of the above named independent local witnesses while complying with the provisions of section 165 CRPC. The following items were recovered: 27 numbers of soap boxes containing suspected narcotic drugs in plastic packets, which was concealed inside of the front side car bumper and inside of so and so. Now, Lordship may kindly come to the next paragraph. The suspected narcotic drugs were weighed by me with the help of digital weight machine belonging to so-and-so and net weight of 297 grams. My lord, may kindly come to the next paragraph. The following inmates of the vehicle were interrogated by me on the spot. Number 1, Saibuddin. Number 2, Tajuddin. After completion of all the formalities, the police party departed from the PO and apprehended these two persons, Saibuddin and Tajuddin. This is the FIR, Lordship. In the FIR, I am nowhere named. Now, my lord, may kindly come to the charge sheet. Page number 29. It starts from page number 25. Relevant would be page number 29. Last paragraph. During investigation, sufficient evidence under section 21C 2529 NDPS Act is found well established against the arrested accused person, namely Saibuddin, address, and then to Tajuddin, so and so. It is also, my lord, this is important. It is also here to be noted that during the course of investigation, several house searches were made, but found the co-accused person, namely Fazlu Miah Salemanuddin. This number 2 Salemanuddin is the petition. And number 3 Sajiduddin from their respective houses to evade police arrest. Next page. During investigation, a prima facie case under section so-and-so have been found well established against the FIR named accused person, number 1 Saibuddin, number 2 Tajuddin. So I beg to send them up to face trial in the court of law under the original sections. So, Lordship, on the basis of this, perhaps, Lordship, the learned court below first framed charge against these two persons. Here, Lordship, nothing is there about the other three persons. Further, I beg to pray, Your Honor may kindly be issued warrant of arrest and PNA against the accused person. These three persons' names are there. Nowhere it is mentioned that against them case has been established. I am not on that, Lordship. Now, Lordship may kindly come to page number 33. Order dated 28/9/2022. Second paragraph, on due consideration of the submission of learned counsel of both the sides and material on record, this court is of the opinion that there are considerable grounds for presuming that the aforesaid accused persons have committed offence punishable under section 21C. Accordingly, charge under section 21C of the narcotic drug so-and-so has been framed against the accused persons. The aforesaid charges read over. Lordship, this is the order related to the two other persons. Now, Lordship may kindly come to page number 66.
This is 12/12.
66, Lordship.
Yes. This is the order dated 12/12.
Yeah.
This is the order dated 12/12.
Yes, Lordship. 12/12/2023. Accused Salemanuddin is produced under arrest by Pathakandi PS case on the strength of NPWA issued against him. And before that, Lordship may kindly peruse order dated 25/7/2023 at page number 55. My lord, got it?
Yes.
Order dated 25/7/2023. Accused Tajuddin and Saibuddin, these are the two persons who were arrested on the very first day, are produced from jail through video conferencing. Perusal of the case record shows that charge is yet to be framed against the absconding accused persons. That means, Lordship, the other three persons. Heard the learned counsel as well as the learned PP issue NBWA against the absconding accused person requiring production on so-and-so. So, Lordship, this is the first time NBWA was issued against the other three persons. And before that, Lordship, may kindly peruse the previous order 11/7/2023. 1 PW was examined. Before taking cognizance even against the present accused person, 1 PW was examined 11/7/2023. Witness Jaira Sinha is examined as PW1, cross-examined and discharged. So, Lordship, basically this is the background of the case. Now, Lordship, the grounds on which I am seeking bail. Number one, Lordship, in the present case, nothing has been recovered from the possession of the petitioner. The petitioner was neither named in the FIR. Even in the charge sheet, Lordship, there is nothing against the petitioner. Number two, Lordship, prolonged incarceration and delay in trial. I am behind the work since last 1 year and 9 months. As of now, Lordship, charges has not been framed against me. Number three, Lordship, in the charge sheet,
Your
there is
charges
no
not been the other two accused persons against whom also the
NPW was
they were not yet apprehended.
one person, he got anticipatory bail from the school. And pursuant to the direction he appeared, he was released on bail. And another person, he is still absconding.
One person is still absconding.
Still absconding. So my first ground would be, Lordship, there is no recovery from the possession of the petitioner. For that, Lordship, I am relying on Tufan Singh's judgment. And second, Lordship, in the charge sheet, there is nothing against the petitioner, what role he has played. In that case, Lordship, I am relying on the judgment of the Honorable Apex Court. And Lordship, third is, Lordship, prolonged incarceration. May I start from the third ground, Lordship, prolonged incarceration? In this case, Lordship, the petitioner was arrested on 12/12/2023. As of now, I have already completed 1 year, 9 months, Lordship. And regarding the prolonged incarceration, Lordship, I am relying on this judgment, Lordship, passed in BA number 4312 of 2023. And in this judgment, in this order, Lordship, Lordship was pleased to discuss all the other judgment of the Honorable Apex Court, Lordship, starting from Ravi Prakash, and all the other judgment has been discussed, Lordship. Therefore, Lordship, I am not supplying the copy of those judgment. Lordship, may kindly come to page number 6, Lordship. Paragraph number 13. 12 and 13, Lordship. Thus, as per section 37(1)(b) of NDPS Act, bail can be only granted if there is no reasonable ground for believing that the accused is not guilty of such offense and he is not likely to commit any offense on bail. But from the materials available on record, there cannot be any reason to believe that the accused persons are not guilty of such offense or they are not likely to commit any offense while on bail. But in the same time, it cannot be denied that the accused petitioners are behind the bars for last 2 years and 9 months and 13 days from the date of their arrest. Until date, the prosecution has been able to examine only 4 numbers of witnesses out of 8 numbers of witnesses. And also, it cannot be denied that to examine the remaining witnesses, the prosecution may take a considerable period of completion of the trial. Here, Lordship, in the present case, cited witness is 9 against, and as of now, Lordship, none has been examined. I would say that, Lordship. And one witness was examined, Lordship, that was prior to framing of the charge against the accused person, Lordship. Present petitioner, Lordship. So, Lordship, here, Lordship was pleased to discuss all the other judgment. I'm not referring all those judgments.
Against you, whether any charge has been framed?
No.
No, not
No,
yet.
no, not. As because, Lordship, the third person is still absconding, Lordship. And my Lord, may kindly take up the next judgment, Dhirendra Kumar Chaudhary's judgment. Only one paragraph, first paragraph I am reading, Lordship. We are inclined to set aside the imprint order only on the premises that trial is yet to begin and appellant has been under incarceration for 17 months. Thus, the principle of right to speedy trial, we are inclined to grant bail to the appellant. So, Lordship, bail was granted on 17 months. Here, Lordship, I am since last 1 year and 9 months. That is 21 months, Lordship. So these are the submission, Lordship, of mine regarding long incarceration. And now, Lordship, so far as the other ground, Lordship, that nothing is there against the present petitioner, even in the charge sheet. No whisper what the offense I have committed, Lordship. On that, Lordship, I would like to rely on specific judgment of the Honorable Apex Court. Only one paragraph, Lordship, very small paragraph I will take, Lordship. Paragraph number 31, my lord. Page number 15. Therefore, the investigating officer must make clear and complete entries of all the columns in the charge sheet so that the court can clearly understand which crime has been committed by which accused and what is the material evidence available on the file. Statements under section 161 of the code and related documents have to be enclosed with the list of witness. The role played by the accused in the crime should separately and clearly mentioned in the charge sheet for each of the accused persons. Here in the present case, Lordship, nothing. Even, Lordship, in the charge sheet, Lordship, there is not a single line as to whether a case has been established against us. The clear statement at paragraph number 29, I have already read out, indicates that case has been well established under section 21C against the two other persons who were arrested on the very first day. Nothing against me. And, Lordship, here, Lordship, the petitioner was arrested, Lordship, on the strength of warrant, Lordship. And in this case, in this regard, Lordship, this is the last judgment, Lordship, I am referring to, Lordship. This is a case, Lordship, where the petitioner was arrested on the strength of warrant, Lordship. My lord, may kindly come to paragraph number 4, Lordship. The learned counsel for the petitioner has submitted the petitioner was arrested on the strength of non-bailable warrant of arrest against him, and as he was shown as an absconder in the charge sheet. He submits that since date his arrest, the petitioner has been languishing behind the bar. He further submits that although there are 9 listed prosecution witnesses in the charge sheet, however, till date, only 3 have been examined, and at this stage, it is unlikely so and so, so and so. So, Lordship, considering the length of detention, Lordship, prolonged incarceration, here also, Lordship, bail was granted, though, Lordship, 3 witnesses were examined. So my case is that, Lordship, listed witness is 9 as of date, Lordship. Even, Lordship, in that case, Lordship, the recovery was from the house of the petition. But my case is better as because, Lordship, nothing has been recovered from my possession. So, Lordship, this is my upmill submission, Lordship. Considering all these grounds, Lordship, may kindly allow me to go on bail with any condition. And my last rejection was, Lordship, bail was last rejected on, Lordship, 22/4/2025. That order, Lordship, I have.
Annexed the order. Have you annexed the order?
Yes, yes.
Which page?
Page number, it starts from page number 10101, Lordship. 100, relevant would be 101 onwards.
Lordship, in this case, the FIR was lodged on 6/3/22, Lordship. And Lordship, the charge sheet has been submitted on 31/7/22. And he was arrested on the strength of NBW, Lordship, 5/9/2023, Lordship. So all this.
5/9. And you
Five-
say 12/12?
No, Lordship, 12/12/2023. So all during this time, he was absconding, Lordship. He is not cooperating. Furthermore, if we go into the order of 103 Lordship, rejection order, the last 16 para 108. Regarding this same person, Lordship, may I read, Lordship? 108. 16. 16 para, Lordship.
Prayer number 16.
Para number 16. Lordship got it?
Ah.
Accordingly, it is observed that some irregularity was committed by the learned trial court while framing the search or during the recording of one PW. The learned session judge is hereby directed to regularize the proceedings after framing the search against the absconding accused persons. So Lordship has directed to, but till now, it has not done, Lordship. So it,
No, it is whose fault?
Lordship.
It is
Two
whose fault?
Other persons are also there. The search has been framed against one person, Lordship, two persons, Saibur and Taj. And this other person is absconding,
And this is the fault on the part of the learned special judge,
Lordship.
because it was not the case that the only two accused persons were being searched.
Lordship.
There was a 5 accused persons, but in spite of that, he or she framed charge only against 2,
Lordship.
the court.
Lordship.
And then subsequently it has come to the knowledge that 3 has already been left the road. Then only the NBW was.
Lordship.
It's a fault on the
Court.
inadvertent default on the part of the court itself,
Lordship.
not the accused.
Lordship.
Because he just pointed out by the order date just forward in the month of July or some supposed to be in 2023, the NBWs were issued.
Lordship.
That is
Lord.
anyway. Otherwise, yes. Any other submission?
Otherwise, Lordship, this person, Saibur,
Hmm.
against whom charge has been framed, he has stated clearly, Lordship, from this person, this present petitioner, he has purchased this brown sugar, Lordship. And immediately after that, he was arrested, Lordship.
What they are accused?
Lordship.
Accused
This
now?
person, Saibur Uddin.
So Saibur purchased
Brown sugar
from him.
Lordship. And after that, he was arrested, Lordship. On the same day.
Yes. Any other? So that is the ground that he purchased the brown sugar from him directly.
Lordship.
লম্বা হব। Okay, pass the order. Bit lengthy order, we pass.
Lordship. Moreover, Lordship, he was arrested on the strength of NBW. That is important, Lordship.
Most probably they have not taken the grounds of arrest.
No, we cannot, Lordship, as because
they
Lordship,
cannot
after
also, because
open the
ground of
procedures,
arrest
read this
question
case,
is
Lordship,
not
I
there.
cannot take, Lordship.
No, Lordship, I am on that, the abscond, he may again abscond, Lordship. I'm on that, Lordship. Because he was arrested on the strength of NBW issue.
But if you go by the order as Mr. Rahman, Ahmed pointed out, most probably on the first day itself, the NBW was issued, whether there was any summon.
NBW
Someone
was
was-
5-9, Lordship.
No, obviously,
Okay,
when the court came to know about the default or the irregularity,
Lordship.
in that case, on the day itself, the NBW was issued against 3 absconders.
Yes, Lordship, on the
Most
very first.
probably there was no order of issuance of any summon. I don't think I will raise it a court.
Lordship.
Highly obliged.
Yes, what is the position here?
May I
This
please,
is
your lordship?
Case diary. Case diary.
Still there is available.
FIR
Yes.
case 11, my lord. In this case, the allegation is that,
FIR
the-
page 11?
my lord, page 11, my lord,
Yes.
and particular at page 16, my lord.
Oh.
The allegation is that on 7/3/2024, the victim was missing, and accordingly, the missing complaint was filed before the police station at Nalbari, my lord.
And after about 6 months, my lord, information got by the informant that the victim was kidnapped by someone and she was confined at Kolkata, my lord, and she was engaged in prostitution work, my lord. And accordingly, this petitioner has been arrested. Her name is not in the FIR, my lord. And in this case, no other persons are not arrested, my lord. My lord, I am behind the bar for 67 days as on today. And I have a breastfeeding child, my lord, of 1 year old, my lord. Kindly see at page 21, my lord. The learned trial court's order is there. And at the earlier stage, my lord, initial stage, the bail period was rejected at that time. Kindly see at page 7, my lord. Page 7 of page 21.
Page 7 of 21.
Sorry, page 21, para 7. my lord. A petition being number, second paragraph, para number 7. A petition being number 717 so and so is filed by the informant and his wife victim, stating that they do not have any objection if the accused person is granted bail, as the accused has a breastfeeding baby, my lord. But the learned trial court was rejected at this earlier for the ground that the case was in earlier stage, my lord. And thereafter, my lord, an observation was given. If the accused petitioner want that the baby should bring to the jail, then as her desire she can. But the police has not taken any initiative, and the baby is now outside of the jail with the custody of other person, not with the mother, my lord. So, my lord, my humble prayer is that considering the period of detention, and I have a baby of breastfeeding baby of 1 year, so bail may be granted.
You have not filed any petition, have you? Is there any order? Is there any petition filed by you before the learned trial court below, seeking the custody, the baby with you?
No, my lord, the court.
I don't think so. You don't have any.
The court said that, my lord, court said that if the victim, the petitioner wants that the baby should bring to the jail, then she can. But unfortunately, due to some lapse of procedure or some other reason, maybe the baby is out of jail, my lord. She is not bringing to the
So
jail.
she could have very well approached before the jail authority or the court concerned that I
No, my
want
lord,
the
the
baby
direction.
because he is a breastfeeding one.
No, my lord, the direction was given to the IO.
See direction was that about what I have done. You
The
haven't
IO.
filed for anything.
No, that
Have
is
you
not.
made any contact with the IO?
Well, I am not arising that question, my
You
lord.
did not do anything.
I am not arising
is
that
having-
question, my lord. My
Anyway,
prayer is that
that's the case. Okay then. Now 67 days she is behind the file.
67 days, my lord. Considering the length of detention, my lord, and the breastfeeding size, my lord. Only in these 2 grounds.
Yes.
Firstly, I want to state here, Lordship, the present petitioner is from West Bengal, Lordship, firstly. And secondly, Lordship.
Is from West
West
Bengal.
Bengal. Secondly, Lordship, there is in the order, Lordship, the breastfeeding part, Lordship, in 29/7/2025, court ordered directed the IO to take necessary steps to hand over the 1 year infant child of the accused so and so to the accused person, Lordship. And in regard to the compliance report was called for. And in that it has been stated that, Lordship, accordingly, efforts have been made to find out the said baby, but it has been found that the said baby is with his father, that is with the husband of the accused of this case, and this now the father of the child cannot be found.
Huh?
Father of the child, he cannot be found, Lordship, and the baby is with him, the husband or the father, Lordship. Under these circumstances, infant could not be handed over to the mother of till now. So the trial court has directed, Lordship, but it cannot be complied because the baby itself is not found, because the baby is with the father, Lordship, on that point. Moreover, Lordship, here are the 3 victim statements are there, 183 statements, Lordship. They have clearly implicated this person. The other persons are also involved, Lordship. They have given these 3 victims, Lordship, to this woman. And so it is clearly implicating, Lordship. She is in the business of illegal trafficking, Lord. She herself also stated that she in the West Bengal, she has a license, Lordship,
For trafficking.
for law trafficking, Lord.
No, trafficking to cannot family. She
As
was
per her
prostitution.
statement, Lord. As per her statement.
No. For
For
she herself engaged in prostitution. No?
Lordship. She brings these girls from various parts, Lordship, and does the business of this kind, Lordship. And but she stated that on their own wish, they have come. But it is not the case because 182 statements are there of the 15. And 161 statement is also there on 180 statement. So if we look into the 183 statements, it is clearly three victims of 3 statements of the victims. 183 statements.
And those the girl which were already been trafficked were used for prostitution.
Lordship. They were in the railway station. Then some other person, in the guise of giving them job, they took to their home, and on the very next 2-3 days, they were sent to this person solely. 1,60,000 has been taken.
Yes, it's okay. And otherwise, she is in 67 days. We do need any further custody.
Lordship, because she is the main person, he will take the girls from many other places.
There
also,
may be
Lordship.
other
Other person
girls.
may be also dead. That need to be recovered, Lordship. Other victim girls. Then she need to be interrogated. Then only, Lordship, this will come. How many other victims are there, Lordship? So at this stage, Lordship, I object. I have objection, Lordship.
My lord, as she is lady, my lord, and the girl was missing from the own home, my lord, and a missing complaint was also there. And at that time, the kidnap was occurred, that is not mentioned. However, she was recovered from Calcutta, my lord. The main fact is that, my lord, this victim took rented in the house of the victim, my lord, the house of the petitioner. That, and she said that she is working in a beauty parlor, my lord. And after some day, the petitioner comes to know that she is not working in the beauty parlor, but she is engaged in some illegal works, my lord. And she was also not giving the rent, my lord. And therefore, while the petitioner and her husband come to know that she is engaged in another works, then she was warned that you have to leave my house. And then due to some, there was some altercation, my lord. And she made a phone call to the husband at Nolbari, and he informed the police that my wife is recovered at Calcutta, and the police went and arrested her, my lord. Otherwise, if that is done, that on her own wish, my lord, there was no force. A lady, how can confine a lady, my lord? Is it possible? And
There are,
my lord, other
this is going on in.
my lord, however, my lord,
A lady can confine.
my lord, 67 days behind the wall,
With
and she
muscle
has
power, with other day with money, manpower, muscle power, the lady can. Lady can confine many ladies. That is the case going on. It may be a lady, and that apart she is not caring for her baby also, because baby is not there.
Right.
Though you are saying that she has a 1-year-old breastfeeding baby,
No,
but
but
she is not.
baby
She
is
is not.
there,
She
my
is not caring for her baby only.
Right.
Where from you are saying?
No, otherwise, baby
She
is
neither
there, my
she is seeking the baby. It is the court only who gave the direction, but that apart she is doing nothing. Because she might have known where her husband is there. Her husband was not available. How can you say this thing?
However, my lord, 67 days, my lord, I will comply in the investigation, my lord, imposing any condition, my lord, imposing any condition, my lord.
Moreover, I only wanted to state that, Lordship, she is from West Bengal, Lord. So it is difficult.
I am ready to give the local
With the
surety.
cooperation, Lord.
I am ready to give the local surety.
Petition. It's an application. It is submitted by Mr. Ajad, the learned counsel for the petition. That the present petitioner is innocent and she is not involved in the LS. It is a fact that the victim of this case came to her house as a tenant, and where she was working in a beauty parlor, but subsequently the accused came to know that she is engaged husband in some illegal work and also defaulted in payment of the rent. On being interrogated and on being and when he sorry, and when she demanded the rented amount, there was an altercation and subsequently an FIR is closed against present petitioner with some false and concocted allegations. She further submitted that the accused petitioner is behind the bars since last 67 days, and she also has a 1-year-old breastfeeding child who is outside the jail premises. Accordingly, she submitted that it is submitted by Mr. Agar that the accused petitioner will extend her cooperation in the further investigation of this case if she is provided with the privilege of it. More so, she is ready to abide by all conditions and will also provide total security if she is practically. Next point. Mr. Das demanded additional PP submitted in this regard that there was an order from the court to hand over the breastfeeding child to the petitioner. And in compliance of the said order, the IO visited the house of the petitioner in search of the baby. But then only it has come to the knowledge of the IO that the baby is with his father of the husband of the petitioner, and the father himself is missing from the place of residence, and for which the order could not be complied with. Next, Mr. Das further submitted that there are sufficient incriminating materials against the present petitioner, and from the statement of the 3 victims recorded under Section 183 CRPC BNSS, it reveals that in the guise of in a pretext of giving a job and for other purposes, the girls were taken by the present petition, and then though they were engaged in prostitution. More so, she admitted in her statement that she is engaged herself in the trafficking of the girls, which were subsequently used in prostitution. Used for prostitution. He further submitted that there are many more victims which are yet to be recovered, and hence custodial interrogation of the present petitioner may be required for the interest of investigation. Accordingly, Mr. Das raised women objection and submitted that it's not a case to extent you will interpret the present petition against each. Next paper. Hearing this submission made by learned constitutional considering the materials available in the case, then issuing the statement of the victim and accorded to Section 1 CRPC. This court is of opinion that further custodial interrogation may be required to unearth some more facts involved in this case, as well as for recovery of some of the victims, which were also trafficked by the petition. In view of this, petition stands rejected. Your petition stands rejected. Petition stands rejected.
Obliged.
11. Anything? 9, 10, 11 we have received.
Yes.
Wait, please, my lord.
You are appearing in which one?
I'm
9.
appearing in item number 9, my lord.
9.
DA number 2637. My lord would find the translated copy of the FIR at page number 13 and vernacular at page number 18, my lord. May I read the FIR?
Yes.
Carried.
Mm.
With due respect, I beg to state that I, Rahul Bora, son of so-and-so, resident of so-and-so, am working as a driver of Saurav Kalita and staying in Guwahati with him. I know the driver Amirul Islam for the past 2 years. After some time of knowing him, he became friends with me. He became free with me, and I came to know from him that he, along with Hemanto, mobile number so-and-so, is indulged in supplying of girls to customer, and a woman named Monica is also involved in the same business. Yesterday, I met Amirul Islam, and he told me that 2 girls are ready and in need of customer for which rupees so-and-so is needed. Then I informed the matter to Saurav Kalita and thereafter informed the police, and later on the police brought the 2 girls with Amirul Islam to the police station. Amirul Islam, Hemanto and Monica are together running illegal fresh trade business, and by charging commission from the customer, they are trapping poor girls, forcing them into flesh trade. Therefore, prayer is made to take appropriate legal action. It is pertinent to mention herein that girls which were sought to be supplied by Amirul Islam are so-and-so, so-and-so. Madam, I am for Silpa Shikha Borgohai and Journal Ali, my lord. In the FIR, my lord has noted that the name of
What,
the
you are
present
for?
petitioner,
You are for?
Shilpi Jainur Ali and Shilpi Shikha Borgohai.
Achha.
In the FIR, my lord has seen that the name of the present petitioner is not there. My lord would come to page number 17 of the petition, my lord, which is annexure 2, is the forwarding report, my lord.
Seventeen is
Annexure 2, my lord.
17.
Page number 17, 1 second.
17 is the forwarding. No, I have not find it.
My lord, it's annexure 2, forwarding report, my
No,
lord.
see, pagination is bit different. It is here. Your forwarding
Pagination,
is that page.
my lord, it would be 19, my lord.
Huh.
I apologize, my lord.
Yes, 19.
I'm reading the last portion, my lord, last paragraphs, because here only my names comes up for the first time. During the course of preliminary inquiry, the FIR name accused person, namely Amirul Islam, apprehended while he went to supply those girls to customer, and he was brought to PS for interrogation. Record the statement of accused, complainant, and witness. During the course of investigation, the apprehended accused person revealed the name of co-accused involved in the racket. Accordingly, on the basis of information received from apprehended Amirul Islam, another 3, namely Hemanto Bora, Jainul, and Shilpashikha Borogai, has been apprehended during the course of investigation. My lord, now would come to the grounds of arrest, my lord, which is the subsequent page, page number 20. My lord, the number 1 point is arrested accused so-and-so are FIR name accused person. They were caught red-handed by the complainant with the help of the members of the public while he was attempting to supply girls for sexual exploitation. Where on basis of statement of them, another arrested person, namely so-and-so, were also caught red-handed along with another 3 numbers of girls. Moreover, in these point number 2, my lord, towards the last portion, my name is again reflected. Moreover, Jainurali and Chitralika Borgohai kept some at their residence located at so-and-so, Hatigao, and sending the girls to different customers on call using the person engaged as Dalal, that is Amirul Islam and Hemant Kabra. My lord, what my case stands here as of now, my lord, on 19/7/2025, in the night, I was going along with Jainur. Shilpashika Borgohai was going along with Jainur for dining with Kalashetra area. In that time, in Kalashetra area, my lord, Punjab. At that particular point of time, near about 8:30 hours, because I know these things, my lord, as I have also reflected in para number 8 of my petition, since on the date of production, I had the opportunity to meet the accused person in the first time. I took as to how they are involved in this particular case. They informed me that they are nowhere connected with the case. They were going for dinner. The lady concerned is a dance teacher by profession, and the boy, particular generally, is basically gives the car on rent and sometimes also acts as a driver, my lord, to the car that he lends. Because when the customer demands so that they do not have a driver, he also becomes a driver in that case scenario. So what transpired, my lord, on that particular day, while they were going for dinner, Hemanta Bora called the present generally, and he told him that he, along with his friends, were going for dinner and they want to dine together. But when Hemantapura came, subsequently the police personnel also came and they apprehended all the three persons.
She and this Janur and this Silpi Shikha, they were also going for a dinner.
Yes, ma'am. And subsequently, Hemantapura called up saying that he wants to dine together along with his friends. Along with him, there were two numbers of girls, my lord, as per what they have told me. So when they were going for the dinner, they all were apprehended on charges as they were in the allegation. My lord has seen that they were known, not named in the FIR, my lord, in the first instance, the present petition M2637. Subsequently, only their involvement comes in. And as of now, my lord, there is 53 days they are behind the custody. Today, my lord, till today, which is 53 days. And the investigation might also have been substantially progressed, my lord. So keeping the accused petitioner behind the bars for such a long period of time, when the investigation is more or less completed, the statements of the alleged victim girls has been recorded. They have already been recovered. Nothing further remains to be done, my lord, as at this stage. This is my humble prayer, my lord. Well, what I'm praying for, my lord, any condition of the bail may be allowed to go on bail.
Wait, please, your lordship. My lord,
You are for
I'm for Hemantapura, my lord.
10.
10.
You are for 10.
Item 10, my lord, 10. Here, my lord, I am also a driver, my lord. I'm a driver by profession, my lord. And my case is at my lord, item number 10, my lord, page 6, paragraph 8, my lord. Whatever, my lord, the informant, my lord, he called me to the airport, my lord. Accordingly, I went there, my lord. And my lord, informant, along with a girl, my lord, boarded my vehicle, my lord. And my lord, then, my lord, this thing have happened, my lord. Actually, the informant called me to the airport, my lord. Page 6, paragraph 8 is my case, my lord. And moreover, my lord, 53 days in custody. And the affair also, my lord, there is no although there are allegations, but there are no specific allegations of any immoral act done, or some girls were recovered, they were handed over to the police like that, my lord. No trafficking or selling of girls or like that. Only a driver lost the case, my lord. That is at page 14. 53 days in custody. So, my lord, further custodial detention, my lord, for the purpose of investigation, because investigation everything has been completed by now, my lord.
You are for 11?
11. Where was?
You are Aminul.
Yes, losses. Losses. From the FIR itself, it's clear that losses. I'm a driver by profession, losses. What
Driver,
happened?
you are also driver.
Yes, losses. In the FIR itself, is written losses. What happened was on the date of the incident.
So you are most probably FIR accused.
Yes, losses. Yes. On the date of the incident, losses, two passengers losses booked, hired my vehicle losses, who were girls losses, two girls losses.
Two girls?
Yes, losses. And accordingly, I drove them to their destination. In the meantime, police came and arrested me along with the two girls losses. What happened, losses? I have a bitter relationship with the informant losses, who is also a driver losses. And in order to take revenge losses, the informant gives a false information to the police, and accordingly, the police has arrested me, losses. And losses, the police has booked this case under section 5, section 5, subsection 1 immoral traffic act losses. Actually, both the girls are major losses. The gravest element of that section doesn't come in this case losses.
These are only for minors?
No losses. Both the girls are major losses. They are 21 years of age losses.
No, you're saying those 5, this immoral trafficking act will not attract this in this case?
No, that is not the gravest element losses. If minor, then it is
grievousness will be more.
Yes.
So they are major.
Yes, they are major losses. Actually, he is arrested on 19th of July losses, and today 52 days losses. Can considering the everything losses, he may be allowed to go on.
So during investigation of this,
He says how many 60 days, 90 days? What is offense?
90 days of So lordship, during investigation, they arrested accused persons were targeted poor girls or women's lordship. Taking advantage of the poor economic conditions of the family lordship and convince them to engage sexual activities lordship and arranging customers for them. And then the item number 9 lordship, join CP Sikha and Joinu lordship. They also keep some of the girls at their residence and sending the girls to different customers on call using the person engagement lot as a broker lordship. And in this connection lordship, some drivers, commercial drivers, during investment it reveals that some of the commercial drivers also engage in this case for racket lordship. And these drivers come into contact with such girls while they are passengers on their vehicle lordship. And
what?
They try to contact some women or girls lordship when they were boarding their vehicles lordship and observing their conditions of the family background. They are offering some jobs to the poor ladies. And later on, when the girls will agree, then they will work for their beauty parlors. And victims are also implicated. Victims statement recovered girls will statements also recorded in this, and they were implicated. And regarding
engaged in beauty parlors. Beauty parlors.
Beauty parlors and some other sex workers operating in other places also. Recovered from other places also. And in this case, item number 10 lordship, they were not victims were not implicated his name also, but the arrested accused, other accused, they have fully implicated that yes, he is involved with us. Otherwise, 9 and 11 fully implicated by the victims. They were they were forcefully engaged us in doing sexual activities, but lots can go to the big statement of the victims. And in on their confessional statement also they have admitted that yes, they are doing this business. The statement of the victims also. They have implicated the other fees, the statement of the victims also. But item number 10, Hemant Bra, he was implicated by the co-accused, not by the victims. My lord, insofar as the statements of the victim girls is concerned, my lord, it appears that although some name has been given, some name has not been given. However, my lord, the case of the present petitioner concern is that 53 days as of now behind the bar, statements has already been recovered. The investigation has more or less completed, my lord. So considering all this aspect, my lord, and in terms of the length of detention, more so, they may be allowed to go on bail, my lord, any condition that part I leave it to you. But one person, I guess, my Mamoni, it is yet to be arrested. He sees absconding yet. As per the note of the IO. For one particular person, my lord, is yet to be apprehended. We are being supported. Considering the gravity of the offense, I have objection also. This regard. Any condition, my lord. Yeah. Had there been no recovery, my lord, then I would have completely denied the same. But there are some recovery which I cannot also deny at this point of time because police had made some investigation and some recovery has been made. Their statement has been reported. So whether I'm in that offense or not would come in the trial only, my lord. As of now, what I'm praying for is only for bail. The last part of the case, there is acceptance of the arrested accused of the other.
Priyanka is also one of the.
Lordship,
Priyanka.
Priyanka name alias is Silpi Sikabura.
Oh. But from their statement, they was not supposed to do this work. So is there any?
Some of the victims asserted that but
any
operating this type of, well, you have to force or not force logic, but operating this type of.
Yes, obviously. Yes. Okay, I'll go through the case.
Not.
It will record. Okay. All right. Yes. Oh, no, let's just I'm keeping this CD. I'll hand it over later. Oh,
Obliged, madam.
Deeply obliged, my lord.
May I please today, Lordship? Today
we have
is
received the
for
case
case diary.
Case diary is Lordship.
Oh. Yes.
My lord, have a look at page 15. The English translated type copy of FIR, Lordship.
Page 15.
Page 15.
Ah.
And 17 is the vernacular, Lordship.
Hmm.
And 25 is the last rejection order, Lordship.
Page number?
25. We are behind the bar, Lordship, since approximately 40 days, Lordship. Considering the length of detention, Lordship. We may be careful.
We have received a case diary, Lordship. Some sewing machines were stolen and main accused is from Babul Rabha.
Some, what is the case? Some proper, machineries. Or what was stolen?
Sewing machine.
Swing
different
machine,
swing
scrap
machine.
swing
That's it.
machine, Lordship.
From the institute.
Lordship. And when it was recovered from a tempo, Lordship, one is here, Lordship, a petitioner, one is the driver of the tempo, and one is the where it was where to be sold in a dam. One is the monsoon and he is the owner of the dam, and other persons is the worker of the that or dam in the dam, Lordship. Under the working under the
Monsoon is the owner of the dam.
Monsoon is the owner of the dam.
Where it was about to sold.
About to sold, Lordship. And second was one is
Saidul Islam was arrested along with the recovered machines.
So Sahidul is the auto van driver.
And tempo driver, yes, and driver. But along with him, one Babul Raba, who is particularly main accused of
So from the position of that
Sahidul and Babul.
And Babul.
Yes, he has fled away from the place of occurrence. He's absconding till today.
So all stolen those swing machines have already been recovered.
Already recovered.
And who is Tal Islam?
Taj Islam is the worker of that dam. He is working under the Mansur Ali.
Maximum punishment.
But the recovery was not from them, but from the auto van. Tempo.
Tempo driver is the Saidul Islam. One or another accused,
He was about to sold all this to that tempo.
Tempo.
Lordship, considering the length of detention, Lordship.
Only thing is that main accused Babul Rabha is yet to be arrested. He has fled away from the place of occurrence when people tried around him. And Saidul Islam arrested on the place of occurrence.
Your Mr. P.K. Das?
Yes.
Mr. P.K. still on counsel for the petition. And also had Mr. D.P. Committee done it. This is an application of acceptance. Say they receive justice. It's right. Subject line Mr. Duff that with an actual petition settlements. Committed any such comments as I did the What is submitted that the on the accused petitions are behind the part since last 40 days, and hence considering their length of detention, they may be released. Mr. Das has submitted that all these stolen swing machines have already been recovered, and hence further custodial interrogation may not be required for the investigation. However, they are still ready and willing to extend their cooperation in the further investigation space if they are granted with privilege of evidence. Next one. Mr. Kusami, the learned additional PP submitted in this regard that from the accused petitioner number 1 was the tempo driver from where all the stolen sewing machines have been recovered, and the petitioner number 3 is the dam owner, and the petitioner number 2 is the worker of the dam of the petitioner number 3, where all these swing machines were about to sold by the accused petitioner number 1. Mr. Musami further submitted that the one more person was present at in the temple, namely one Babu Brava. He is yet to be apprehended by the act. Accordingly, Mr. Goswami submitted that this may not be a big case to allow to grant bail the petitions. Next further. Hearing this submission made by Learning Council for Books. I have also produced a case diary, and it is seen that there are sufficient legitimate materials against it. Considering the length of detention already undergone in this petition and the recovery of the swing machines, I find that further custodial interrogation may not be necessary for the purpose of investigation. In view of this, I find it difficult to extend the privilege of bail to Sonapur hole Kamrup Metro.
Kamrup Metro.
লিখে দিব to the satisfaction of CGM. Okay, you will grant it bail. Your petition is allowed.
Made please, your lordship.
14 what
And copy of trial court records is not received yet also. That's for all.
Otherwise,
Is it a charge sheeted case?
charge sheeted case, my lord, and accused is behind the bar since 78 days, my lord. And earlier, your lordship has already directed the accused petitioner to appear before the court since charge sheet was submitted, my lord, and which shall be considered by the learned trial court as per law. And accordingly, I have appeared. I have made appropriate application that was rejected, my lord.
Case was registered under which section?
Case is registered, my lord, under the 318 to 69 351 3 BNSS, my lord. Still, allegation is that, my lord.
No, it's okay then. We are not going to hear the matter.
Lordship.
Anyway, what is the
On the
vote? It's not received.
That's for record is for procedural. So we
Lordship, kindly a short date may be given, my lord.
record proceed. Receiving after records proceeding continued.
From the office notes, from the office note dated 8/9/2025, seen that the scanned copy of the trial court record is still awaited. Poster registry is hereby directed to issue reminder to call for the trial court scanned copy of the record with a direction to send the same before this court on or before the next day. And it should be on or before next day. It is a case of this Kamur Petro or
No, my lord. Jagiro case
Morigaon.
pending before Morigao Sessions Court.
Before vacation.
Short date. Kindly short date may be given, my lord.
Short date money we have a vacation now. And the last week will be considered as a motion day, motion week. 24 month later. The 3 month wait on 23rd of September.
23rd
3rd of September.
September. Okay, if possible, can it be on 16th, my lord?
No, no. It won't reach.
Oblige, ma'am. Oblige, ma'am.
15, what is the
We have not received the case diary.
city not received?
It is not in time. In time is there? No, in time.
You are on 16th?
Yes, there is interim, my lord.
City not received, issue reminder. Yes, after vacation you give a date.
After
15/10,
Not.
based on 15/10/2025. Interim be extended, please. 16, what is the position?
We did not receive. Very one interim.
You are on interim?
Interim lecture.
After vacation, not
15/10, we have fixed many matters. I think maybe on 16.
Okay.
16/10. Okay, order. We are extending your interim.
Interim. Oblige, Lord.
Seven also same prayer also. We got interim, but we have not received the case diary.
Long pending, my lord. Bail petition, my lord. It may be absolute, my lord, because my lord, the petitioner reported the police and their statement already recorded in the police station.
Earlier CDs you are lordship, but after that CD was called for, that was CD was taken back, lordship, but it was not severe.
Same order. With a direction to the RM to
16/9
positively on or before the next test. 16/10.
16/10.
16. Interim be extended till late.
We also CD not received.
Here also you are on interim. You are on interim.
Lordship,
18.
on last occasion, case diary was called for lordship and interim was there, lordship. But
Interim there.
yes. And as per my instruction, lordship, search sheet already been laid down, lordship, in this case.
Is it?
Lordship.
We have not received any instruction regarding substitute.
In your lordship, interim may be continue till their instruction, lordship.
You are Mr. I am in.
I am in, lordship.
Heard Mr. I am in, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP appearing on the state response. It is submitted by Mr. Goswami that CD not received. However, Mr. Amin submitted that as per his information, charge sheet has already been laid in the present case. In view of this, Mr. Goswami will take the necessary instructions from the IO. List, you can list it by 19 or 19.9, we are listing it. 19.9, 2025. Till the interim be extended till next.
Obliged.
20 also you have not received a case diary. Then interim. Name also?
Not received.
Not received.
Same order, city not received, issue reminder. List on 16/10.
16/10/25.
Interim be extended till next.
Obliged. 21 also same prayer also. We have not received a case diary. It's not an interim.
You are on interim. City not received, issue reminder. Have you filed your wakalat nama here? No.
Sorry, Lordship.
Have you filed your wakalat nama in this case, or you are appearing on behalf of Mr. Surajit Das?
Yes, Your Lordship.
You are Mr.
S. Chaudhary.
S. Chaudhary. Heard Mr. S. Chaudhary appearing on behalf of Mr. S. Das, the learned counsel for the petitioner. And full stop, city not received, issue reminder.
17/10.
17/10. List the matter accordingly on 17/10/2025. Interim be extended till next invest. Your interim, we are extending your interim till next invest.
22 also we have not received a case diary. Earlier CD was here also because self-updation.
Most probably you are not on interim.
My lord, not interim.
It is a case of 103. 103. Why you have not received the case diary here?
Lordship, CD was received earlier on, Lordship. It was sent back for PM report for FSL also. PM report is keep on pending because the FSL not received yet. So FSL for
But they are not interim. Can it be listed before vacation?
before vacation.
City not received. Full stop, it is
22nd or 23rd.
It is submitted by Mr. Goswami, the learned additional PP, that earlier the CD was received, but it has to be sent back for updation and as well as for furnishing of the FSL report. In view of this, later fresh reminder request with the direction to the concerned IO to furnish the case diary along with the FSL report on or before the next date of this list accordingly. And when it can be listed?
23rd. 29.
23rd of the night. We have not received your informant appearing. 23rd of September, we are listed. None appears to call the.
We have received a case diary.
You have received, no? Was there any interim earlier?
Interim was there and yes, appeared with
City, none appears to call for the petitioner. City received. It is the matter on 24. Otherwise, we are just about to write the order because we have received the.
No, sorry, Lordship, I just came.
Okay, we'll take after 5 minutes. CD.
No, it is CD.
CD is here. Lordship.
No, we are going to just for a small break, for 5
Oh,
minutes. CD is available, I think.
Lordship.
Earlier, you were on interim.
The interim, he appeared, Lordship, cooperating with the investigation.
Cooperated.
Lordship.
Yes, Mr.
Mama. Lordship, granted interim Lordship, and we have appeared, our statement has been recorded as per our my information. Later, case diary was clear.
Statement recorded that he has appeared. allegation is he was in the CCTV footage, he was viewing the comprised way.
That lordship, we have a shop there and
You admitted that you were walking.
lordship. That is the case. Later on, lordship have given interim, not on motion stage, lordship have given it. Later on, on second occasion, lordship have granted interim.
On that premises, he was one there to collect some water from the well. That's why he CCTV in the CCTV place, he was shown in the CCTV place.
No, as far most probably as so far I can remember, Mr. Muni's submission was there that obviously he will be captured in the CCTV because he resides in that
Yes,
compound.
that is
That apart, what did the other
things are not in the case. There, nothing against him. Only his statement is he has appeared in a statement recorded. Here, as per his statement, that I went to a well to collect water. That's why I'm viewed in the CCTV place.
But it was the occurrence was in the night or in the daytime.
No, daytime, lordship.
What's it?
The FIR itself says that the informant has come back home at around 6 p.m. in day, but when I went to office. Lordship have all well remember it. Lordship.
Investigation is still going on, lordship, regarding the theft, lordship.
Mr. Esmir, Mr. DP Goswami, an application it is submitted to Mr. Moni that operating the offer of interim period spell on 13/8/2020, petitioner appeared to be I and extended his cooperation in the investigation. He further submitted that his statement is also recorded. His further he is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of witness. Mr. Goswami did not that the accused petitioner appeared before the RI and cooperated with the investigation of this case, and his statement is also recorded. Considering the submission made by unconstitutional and papers, case study, vis-a-vis the conduct of the petitioner and conduct pastoral interrogation may not be necessary for the purpose of investigation. In view of this, the order of interim period spell dated 13/8/2025 is hereby made absolute with symptoms.
Much obliged, your lordship. Much obliged. Much.
24 years update CD was called for, but CD we have not received the update.
Well, last time your lordship has directed my lord, lordship kindly to give the my lord statement. Statement has been recorded, my lord. And
So
other
statements, if statements have been recorded, you have not able to.
CD's last order of CD was some statements are there. This petitioner statement is not here.
No, I couldn't ask it. Subsequently, Lobo said.
When I joined,
Yeah,
CD was not taken back from our office. That's why CD is lying in our office.
Oh, yeah. Okay.
Last order 19/22/8/25 is the last we have received again 19/8/25. So we have intimated on them 26/8/25, but they have not taken back this case there. That's why the statements are not.
So from where you have collected this statement?
Accused person has given to me, my lord.
Is there any?
My lord, he has
type
given
of
only
practice?
receipt, my lord.
Huh?
When we visited the police station, accused person has given this, my lord.
He was to it.
My lord, that my lord, that my statement, I have appeared before the police, my lord. That my lord, signature before the IO.
Is it a statement or?
No, my lord, it is not statement, my lord. That I am
You have
appeared.
appeared.
Oh, yes, my lord. Interim also. Other accused person is already on enlarged on bail, my lord. When this, my lord. On that day, my lord, because my lord, I got the interim on the later, my lord, in my case, my lord. So, my lord, CD was not up to date. Your lord say again directed you go appear before the investigating officer. I appear.
Other accused statements here, but this petitioner statement not in the case there.
No, but when you appeared, okay, you have appeared. It is.
Yes,
It
ma'am.
says
I'm,
there.
I'm happy.
So what about your statement is recorded?
The statement has been recorded.
Already recorded.
Yes, ma'am.
Part Mr. N.N. Bicham, done a also petition. And also part Mr. P.P. Goswami, done a additional PP to include statements. Next, right, submitted by Mr. Goswami that updated CD is not received as the IO did not return back the case diary in spite of the order of 22/8/2025. In that context, Mr. Chaudhary submitted that in person to order dated 22/08/2025. The petitioner already appeared before the IO and his statement is also recorded. To substantiate the same, he also produced one compliance report stating that he appeared before the IO in compliance of the order. In view of this, the late updated CDB call for along with statement of the present petition, which has already been recorded as per information received by Mr. Chaudhary. Additional, we were directed to return back the case diary with a further direction to send the updated one. Please the matter accordingly on 16/10/2025 for updated CD until the next date of listing. The interim order for the petitioner be extended.
Yes.
We have recorded that you have already.
Yes, fine. And the one thing is that the injury is simple in nature. Other co-accused when released on bail, my lord.
That was an
Yes, my lord.
observation.
Injury is simple. That is why injury on bail.
Consider it.
matters. Good.
If they need, they can.
As your
If you
lordship,
need, it can be returned back.
I know.
May I please?
Yes.
Petitioners are in interim lordship. They have appeared before the investigating authority.
CD received, yeah.
Yes, charge sheet submitted this paper.
Charge is submitted.
Yes, sir.
What is the CS number?
CS number 80/25 dated 30/08/25.
You were on interim, no? You were on interim. Interim to extend to it for 15 days. So we are extending your interim till 15 days. And you appear before the learned trial court below with an appropriate bail application for regular bail. And till then, till 15 days, we are extending.
Obliged.
26. 26, we have not received the case diary.
It was FSL was also called.
Yes, Prachi. That's from Zagiro.
But most probably they were not on interim. You are not on interim, I. City not received, issue reminder with a direction to the IO to furnish the updated case date along with the FSL report. On or before the next list accordingly. When it can be listed?
24/9/25.
24/9 we are listing it.
Obligation.
It will be from okay.
May I please, Dana? Lordship, on the last date, report has been called from the IO as well as from the line trial court. And this is an application for seeking interim custody of a night super bus, which was seized in connection to an NDPS case, Lordship. And in the meanwhile, a confiscation proceeding has been initiated by the prosecution and based on which a report has been called for by this honorable.
I have not received any report, Lord. But one thing is that it is only stated that charge sheet has been submitted. The information is there.
But my
Regarding confiscation, I have no information on that, Lordship. And
Okay.
moreover, if I want to state here, Lordship, regarding this bail Jimma petition, Lordship, in page number 38, Lordship, the petition, Lordship, may kindly look into it. Page number 38, Lordship. On what ground the Jimma petition has been rejected? And the ground is valid ground, Lordship. It is legal and reasonable, Lordship. May I read, Lordship? Third para. Okay. I have perused the record. There is a secret chamber in the past. Presence of such a chamber indicates that the driver and other persons in charge of the vehicle was using it for transportation of contraband on a regular basis. Lordship. And that apart, in the case at hand, more than 1 kilogram of heroin was seized, whose market value will not be less than 1 crore. Lordship. So it is a
And where from you are saying that that confiscation proceeding is already initiated?
We are handling the case in the learned trial court, Lordship, and yesterday was the case fixed. We appeared before that court. Since Lordship, the honorable presiding officer has been transferred, the no proceeding took place, no hearing took place on that regard. And the next date is fixed on 23/9. And with regard to the confiscation proceedings, and we have informed the trial court that Jimma petition is pending hearing. And on the point of confiscation, Lordship, I want to place 2 lines, Lordship, that upon my little understanding and knowledge on going through section 63 subsection 1 of the NDPS Act, which clearly states that confiscation proceeding has to be considered only at the conclusion of the trial. And that has been discussed in the Biswajit Day judgment also in para 21. Only after
If you go by the Biswajit Day,
yes,
it's a bit different. I think I have to go anyway, by impression. But question is that whatever, rightly, wrongly, I'm not on that. But the question is that in the present circumstances, this confiscation proceeding has already been initiated. As per your information,
prayer
we
has
don't
been
have
made
any
by the
information. Sir.
prosecution. By the prosecution, a prayer has been made for confiscation, but no hearing on that regard has been taken place till date. Till date,
Till
no,
date.
Yes, no hearing has been taken, and that is pending before that court. And after Biswajit Day, Lordship, this is one recent citation of the Honorable Supreme Court 2025.
Here, Mr. Das, in the order itself on 10/7/2025, it reveals that the charge sheet has already been filed. Here, it is already reflected in the order itself on 10/5/10/7. That means at the time of this filing of the Jimma, the charge sheet was already there. So they have already approached the London trial court below. Therefore, that was rejected. So we need the report, and now you were saying that the petition is still pending. That's for confiscation.
Yes.
So I don't know what will be the order, or at present it's not a position to say anything because the petition is yet to be heard, I think.
Yes.
So, but is there any observation in the learned trial court below that due to pendency of the Jimma petition before this court, the confiscation proceeding is, I mean, it's not heard, or is there?
No, nothing. Just date for hearing has been fixed. It was fixed yesterday, which could not proceed further due to transfer of the. Apart from this, Lordship, I am not an accused in the instant case, nor I have been mentioned. My name has been mentioned in the charge sheet. The charge sheet is there along with my petition. And Lordship, I have a order of the coordinate bench, Lordship, in similar circumstances where there was secret chamber. Even when there was secret chamber, the driver and the handyman was arrested. Even then, the owner was granted the
Question
interim
is that
custody.
the knowledge is very essential. Whether your petitioner or the owner has any knowledge regarding
Yes.
that is very important. So I don't know. We have to peruse the record also. I think apart
otherwise,
from the
Lordship,
call for IO report. That is also not received. Lordship. Otherwise, Lordship, it was called for.
It's been 9 months, Lordship. The vehicle is in custody. And Lordship, with regard to the knowledge, Lordship, what the petitioner wants to say is that, Lordship, I have annexed one document that I have plied my vehicle to one transport agency, namely Trishul Transport, and they were the one who booked the driver, and my vehicle was under their custody. So with that regard, the investigation agency has not mentioned anything in the charge sheet about Trishul travel. However, Lord Chair, I have annexed the document on the date of arrest.
No, it's okay. Your car was in, I mean, your vehicle was in under the custody of the tissue driver whom
Yes.
you have given, and the
Yes.
driver was there.
Yes.
But the question is that the secret chambers were there.
Yes.
That is the main issue. Otherwise, it's okay. It is a simple case that you have made.
Yes.
But those secret chambers were made in without your knowledge, or you were not aware of that, because the secret chambers was made for that purpose only, for
Yes.
carrying those contraband. That is the case. That's why we differently. Let us call for the report. Do you want the record also? No, I don't think record is not
Record,
necessary. But
otherwise-
CD may require to
Order should
claim
leave it there, Lord, otherwise.
if the knowledge is concerned, we want to return
Oh,
that.
then we have to
In
go to
that case,
record.
so record will be
Record.
necessary.
Otherwise, then record may be called for, Lord.
Scan copy of the record as well as along with the case diary
Lordship.
and the
It will
report from the IO.
It will do.
Because if as per your information, confiscation proceeding for that hearing is still pending. It's not done due to absence of the court.
Lord.
So let us call for the case diary also, along with the scan copy of the case diary record. Because part MS Alboni, the learned counsel for the petition also parts. KK Das, the learned additional PP, appearing statement. No, we had already called for it.
Not
Yes, once it has been
We have
Scan
not.
copy of the record was
Yes.
also called.
Okay, Lordship. It is
Yes.
also not received.
Not received.
Not received.
Scan copy of the trial case record along with the CD not received, and the order of the status, present status report of the case. It was status report actually of the case, whether any order of confiscation was passed by the trial court. That was that we called for. Not the report from the IO. Was there any order for confiscation? That was the issue. But now she has submitted that order is not yet passed because of the court was absent. So which is the next date fixed for?
23/9.
23/9.
After that, Lord.
Then
Maybe before that, Lordship, because
Otherwise,
that
before that
will
not do, because our purpose is only that one.
Lord.
Before that will not be possible, or better not to give in fact.
Lordship, considering the confiscation as in a concern, Lordship, that should, the prosecution should not have filed for confiscation at this particular point of
Whatever,
time.
but the question is that an order will be definitely passed by the learned trial court below in regards to confiscation,
Yes.
unless and because order is, we have called for the status report of the case
Confiscation.
record regarding the order of confiscation.
Lord,
That's why I'm
that
saying
is
that
why, Lord.
if the matter is fixed on 23rd, and prior to that it will not serve
No,
serve the
no,
purpose.
No.
So in that case, too, obviously it will be after vacation.
No.
Lordship, maybe at least maybe before vacation, maybe 26.
It will
Okay.
do. It
That
will
the
start the
motion,
file.
there will be, your matter may not also reach also in that case, because admission matter may not reach. Because that last week will be a motion week, I think. So I think better to take out the month of October immediately after vacation. That
Not
is on either
immediately.
13th or 14th.
Immediately, Lord.
Then it will help.
Lord.
And 14th, Lordship.
14th.
Mm.
Listen also, and so they reported that the scan copy of the TCR along with the case diary and the status report of the record as called for is not yet received. The history will do the needful in calling, in issuing reminder to call for the scan copy of the case record along with the case diary and the present status report along with the order of confiscation, if any. Okay. This is a matter of 14th. Okay, well, listing it on 14th.
No.
Hi. What is the position of 5? Do we need anything here?
Yes, we have.
Yes.
In regarding to this, we have the report.
Report was called for.
Yes, Lord. We have the report. Lord, may kindly.
So otherwise, you claimed yourself to be the owner.
Yes, Lord.
So you are Rubul Bhuyan.
Yes, Lordship.
So only this report is there, na?
No.
CD is there, no?
Or it is called for the regarding Jimma.
But I think this report needs to be verified through CD.
Last.
Because what report says that now 10 kettles are only alive,
Yes, Lord.
and you are also identified or claim yourself to be the owner of the seized kettles.
Yes, Lord.
But those kettles were actually about to transport it for the purpose of sale to the other states, which your law doesn't permit unless and until you have any license on that or the authority permission is given. So that's why I'm saying that on the basis of this report, your position, your Jimma may not be considered. So that's why I thought that if suppose CD comes, then we can verify whether those cattle were actually purported to be transported to the other states or not. Otherwise, from the report, report is there that you were trying or you were the purpose of for sale to the other states without any authority or without any proper or prior permission, because other states you cannot transfer the deliver the cattle to the other states.
Lord.
So in that regard,
Actually,
I think that CD will help us because there may be some statement. Otherwise, your this report consider if we consider this report, your petition may be dismissed. That's right. Better because it is only an aberrament, a statement that you're trying to sell it to the other states.
Last occasion, your Lordship only called for the Jimma report, your Lordship. That's why.
No,
I think
in that case, we are not in a position to say anything. We thought that Jimma report will be sufficient. But now this report is there that those cattle may not be handed over to you because you were trying to, or your purpose of this carrying those vehicle in a carrying those cattle in a vehicle only with the purpose to sell it to the other states, which is not permissible.
actually, Lordship, they are not traveling to other state, Lordship, interstate.
That's why.
Lordship, to
That's why
Morigao,
your claim most probably will be
from
there.
Borpeta to Morigao district, Lordship. From Borpeta to Morigao district. Lordship.
For what purpose?
For selling, your Lordship.
In Morigao market.
Registered market.
Registered market.
Yes, Lordship. That is the actual fact, your Lordship.
That's why I thought that unless
Already
we don't have anything before
petitioner approached before the IO, your Lordship. His statement also recorded.
No, these are okay. That you are also maybe the owner, but
so
your purpose of carrying this vehicle was only to sell to the other states.
Lordship.
As per the report.
Lordship.
I'm not otherwise. I'm not saying. But that's why without the CD, how can we say that you may be innocent? Also, you may not be involved. But as per the report, you were there to only to transport those the cattle to other states.
Lordship.
Like sometimes we see them to Bangladesh or even to other even other country or states, maybe Meghalaya or something. There are many cases where the cattle were being transported to even to Meghalaya, and that part the Bangladesh is the honest. Better to fall for the CD.
Short date maybe given your Lordship. 26/7/2025, the cattle are
in custody.
Custody. Your
Already
Lordship.
6 numbers have died also.
These 6 cows already died, your Lordship. And a short date may be given if possible, your Lordship.
You are Mr.
S. Rahman.
Heard Mr. S. Rahman, the land counsel for the petition. And also heard Mr. K. K. Das, the land petition PP, appeared on the state respondent. The report is received from the concerned IO, but on perusal of the case report, this court is of opinion that CD needs to be verified, perused, and accordingly call for the case diary. Scan copy will do, because you need only for the purpose of the scan copy of the case diary be called for. Report be kept along with the case record. This the matter.
Lordship, it may be considered as a part of record.
Maybe it may be considered as a part of the record. Be kept as a part of it. Not possible.
Already 46 days.
46 days is okay.
Lordship.
We are not in a position to settle. Paralytic different. পরিবর্তন নাই, ডেটিং নাই। $25 prior to vacation. I have given somehow. 25/9.
Lordship.
On last occasion, my lord, scan copy has been called for.
Who is response number 2?
Well, informant. We have an
What is
inspector.
the report? Service report is abated. Case record.
Otherwise, he is a register person.
FIR register.
We can represent him, Lord. Otherwise, we can represent him, Lord.
Who is he?
Informant. Informant.
You are going to represent?
Lord, we cannot. Some informant represent for you, but yeah.
By name, if it is, can be.
But
By
any
name, it is by
specific
name.
allegations is there or by name.
By name.
Okay, Lord.
It cannot represent.
Lord.
Office note says that it's not received.
But he is retired, Lord. Otherwise, he is a retired person. Respondent number
Retired,
2,
na?
Lord.
So where from?
Making him a party, otherwise, Lord.
The difficulty because if we not arrange him as a party, then the registry will not allow. That's the issue.
Retired person.
Otherwise, only the state of Assam is required
This may not be a
because we are
may
not.
not be a necessary party, or
yes.
otherwise he could have made the only the inspector of or the in charge I don't know. This type of cases, do it is, I think it may not be necessary for implement of the informant.
My lord,
There are
Because
some,
only the completion of the formalities because this has been done. Otherwise,
but
registry. is
now
not-
to by name you have made parties.
My
So what to do? Is there any source to know his proper address?
That not
Because
possible.
police station will definitely have his proper address. Otherwise, he was, as per you, he was the inspector of police. Police station
Because
of
there
Guwahati.
there is no allegation against the IO, my lord. Only the formal party we have to.
He was the he lost the FIR, I think.
My lord.
That's why you have made party.
My
I
lord.
know. But
Otherwise, in earlier
otherwise
occasions,
he is not
earlier
a necessary
occasion we
party.
not required to arrange. Only the state of Assam public prosecutor is required. But the because of the formalities.
Now our problem is that you have already made party by name. That
My
by name you have made party.
My lord.
A state of Assam is the only party.
My lord.
To some, actually, if you go by the nature of the case.
My lord.
So, but you have by name you have made party, and then what to do? We have to wait for the service.
No.
Otherwise, when your case is fixed and when?
My lord, 15 coming 15.
Then take it a date after the vacation. 15.
Because
Let
that
the
will be the evidence. I think for evidence, my lord.
evidence.
Evidence.
Somehow you can take adjournment. What I can say? Because
My
before
own-
15 it's not possible at all to fix a date here.
My lord.
Somehow you take an adjournment, if possible.
Lordship, if some observation, then otherwise, my lord.
And that report we have not received the case.
Scan copy or
Yes, case record illuminate. The scan copy also we have not received. It is to be received from CGM Kamrupam only, na?
My lord, my lord.
Kali ma deri ahote. Kamrup metro pa ahibo lage. Iman dihor duro pa ahibo to nalage. Kamrup metro pa ahibo kani iman time lage. Both
Lordship has picked the matter only because 15 is the date for evidence. That's why Lordship has is to fix today, my lord.
now definitely.
And
we
since
have
it's a
what
Kamrup,
to
my lord.
do now. That is the
Understood.
case. We have
Some
heard
kind,
Mr.
Lordship, some kind of observation is then it will help in taking a adjournment on 15, my lord.
That cannot be. I'm just verbally trying to cooperate you, you can take, you may approach the court with an prayer for adjournment. That
Right.
much I can take, but that cannot be any reflection in the order itself. Heard Mr. Ashram, Tilani petition, also heard Mr. K.K. Das, Tilani additional PP, appearing on the of status. As per office note dated 8/9/2025, services awaited for the respondent number 2. In the same time, the case record, scan copy of the case record and the case diary is also awaited. Issue reminder calling the case scan copy of the PCR along with the case diary. And await for service report till next. Could be after vacation, Mr. Sharma. We don't have any date, or
My lord,
rather it will not help you also.
My lord, can it be, my lord, if the lordship will can observe that my submission that the lower court case is on 15, at least that maybe, so that on that basis, at least we can take it, because if the witness are not.
Mr. Sharma further submitted that the next date before the trial court is next date before the trial court is fixed on 15/9/2025 for fitness, and accordingly he sought for short date for the presence. However, considering fact of the case that the but as the case record and the case diary is not yet received by the registry, and that effort the services also awaited for the respondent number 2. Let the matter be listed accordingly on 15/10. Okay, we made an objection.
So I am only pressing because I'm not directly or indirectly connected with the case. That's why I'm praying, because I am not the director, only the employee. My lord. 29. How much?
Wait, my lord, scan copy was called for, and also I was asked to take steps, my lord. I have taken steps when scan copy was also called for. And basically, my lord, it is a passing of a FIR.
Concerning the submission of Mr. Mohanto, we had give a short date on
Yes,
one it was fixed. So what is the now position?
Scan copy not received.
Not received. Therefore, it has to receive it.
Sonitpur.
From?
Sonitpur.
Sonitpur. We call for the case diary here or case record?
Case record.
Case record.
Case record.
Probably scan copy.
Scan copy of CD lot.
CD, yes. CD was because case is still under investigation.
Under investigation. There's several civil cases pending, and my lord, after there's a everything I have annexed, my lord, and that day I will also
Yes, I
transfer
have
everything.
discussed
My
your,
lord.
your case also.
My lord, and we file a FIR, and as a counter to that, very next day this is been filed.
Yes, can it be abated prior vacation to
Prior
penalty
vacation, my lord,
possible?
even in listed, it will be difficult to dispose of, my lord.
Maybe.
My lord.
Can it be on done immediately after
My
vacation
lord.
that is on
My
14th
lord,
of
I
April?
understand, my lord, your lordship.
Because
I mean-
even if it is recorded, because this
yes,
week will be motion day, motion week, so
because probably last 2 weeks, my lord, will be next 2 week will be the
next 2
motion
weeks
day.
will be yes.
I agree, my lord.
Part Mr. T.J. Mahanta, the learned senior advocate, assisted by Mr. M.P. Sharma, Lord M.P. Sharma, the learned the petitioner, and also part Mr. K.K. Das, the learned as part of office note dated 8/9/2025, the service report in respect of respondent number 2 and the scan copy of the case diary is still awaited. The registry will do the issue reminder or issue reminder in calling the scan copy of the PCR will be called by you or by the registry.
No, we will also. CD, as it is not solicited lot, we will call for that.
The 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 learned additional people will take necessary steps in the case diary. A scan copy of the case diary.
আপনাকে বিক্রি করলে যে কেউ সে কিনে বিক্রি করে মুখ
And
দিয়ে আমাকে
report of
অন্যদিন
service report of the respondent number 2 be abated till next day.
কোথেকেও
This
বিল
matter
দিয়েছে কোথাও
on 1410. You try to get an information because 1410 we have fixed. Case is what Mr. Mohanta had submitted on the last occasion. It seems that there are civil disputes are there.
already they have
That-
filed a case.
That part, but as the case is still under investigation, we cannot pass any order or stay of investigation.
My lord.
That's why his diary.
I will definitely call to.
1410 well.
My lord.
Yes. What is the position here? Scan copy you have received here?
Scan copy of half of the LCR had already been received, and 161 statement and other part, as per my knowledge, I had been appeared before the trial court on 27/8/2025, and they informed me that they already sent the scan copy before the before lordship, but they did not annex.
But it is in the office note, it is stated that awaited.
But it is not.
Office note, it is stated that 99. 99 order. Office note.
On last date, I also submitted the same.
Awaited.
When it was earlier which we have received, it was not
Completed. 161 statement they did not send,
Were not
but after that they sent it.
You got the information they have already sent.
Sent
From which court? From which place?
Huh?
District? Which district?
Kamrup.
Kamrup Metro. Amingaon.
Amingaon.
You are MS?
J. Soikia.
MS J. Soikia, Dilane Constable Deputation. KK Das Dilane. Additional PP appearing on behalf of State Department. It is submitted by MS Soikia that there was not earlier the TCO was not complete as the statement recorded under section 161 CRPC was not available. But as per her information, the learned trial court widow has already sent the updated case record. But as per office note dated 9/9/2025, the updated case diary along with the statement of 161 CRPC is still registry is hereby directed to do
Interim, there is an interim.
do the needful in calling the updated scan copy of the TCR along with the case diary and the statement recorded under section 160 CRPC. Interim order passed earlier shall continue till next day. List the matter accordingly. After vacation, it will be.
No, date may be fixed.
One date. Listing it on 16/10 after vacation.
Obviously.